If you have a living trust in California, it may not be doing what you think it is. I am Ali Talai, an estate and asset protection attorney, and in this video, I'm going to walk you through 5 common but costly mistakes I see Californians make with their trust. Mistake like assuming your trust protects you from lawsuits. It doesn't. Failing to update your trust after major tax law changes, or leaving your children's inheritance completely vulnerable to divorce, creditors, or bad decisions. If you already have a trust or you're planning to set one up, these are the real-world risks you need to know about and the steps you can take to fix them before they cost your family dearly. Mistake number 1, thinking your family revocable living trust protects your assets from a lawsuit. I've been practicing asset protection law in California for years, and I see the same trust mistakes over and over again, and this is probably the biggest misconception I encounter. People come into my office all the time thinking their revocable living trust is going to shield them from creditors and lawsuits. And I have to break some bad news to them and let them know that it won't do that. Most trusts are created to avoid probate, not to protect assets from creditors. A revocable living trust, which is what most families have, offers 0 asset protection while you're alive. 0. You can revoke it, you can control it, you're the trustee, and legally those assets are still considered yours for creditors' purposes. I had a client last year, a successful contractor, who thought his multi-million-dollar home was safe because it was in his family revocable trust. Unfortunately, when he got sued by a subcontractor, he learned the hard way that his revocable living trust provided no protection whatsoever. The plaintiff's attorney went right after the home, and there was nothing the trust could do to stop it. Under California law, if you retain any power to revoke or modify your trust, creditors can reach those assets. California Probate Code Section 18200 makes this clear. The assets in a revocable trust are treated as if they are still owned by the settlor, that's you, the person who creates the trust, for the purposes of creditor claims. So if you're thinking about how do I actually create a real asset protection planning, in many cases, we have to implement and use a trust that is not a revocable trust. It would have to be an irrevocable trust, that you don't have the power to revoke the trust. Usually if a creditor files a lawsuit against you, they step in your shoes. So whatever power you have, they'll gain the same power. So in a asset protection planning, if we're doing something for you, we want to make sure it's step 1, that your trust is not a revocable trust, that it's an irrevocable trust. And all that means, we want to create a trust that doesn't give you the power to revoke the trust just by yourself. We could have somebody else within the trust and that person could have the power to revoke it, but you cannot solely have the power to revoke it. And there are obviously other structures that we could put in place, like LLCs and limited partnerships, and together we could create a great asset protection planning for you while you're alive. All right, so mistake number 2 is not properly funding your trust. This one makes me cringe every time I see it. You spend thousands of dollars creating a comprehensive trust, and then you never actually put your assets into it. It's like buying a safe and leaving all your valuables still sitting on your kitchen table. I see this constantly. People sign their trust document and then they just put it in the drawer and that's it. They completely forget about it. But the reality is that if you don't actually transfer or assign the interest in the assets that you own to your trust, this trust, no matter how great it is, it's not going to do a whole lot for you or your family. The problem is that unfunded trusts create a legal nightmare when you pass away. Your family ends up in the probate court anyways, dealing with exactly what you were trying to avoid. I had a client whose father created a trust, but unfortunately he never transferred the family business into it. And when the father passed away, the business had to go through probate, which took over 2 years and over $100,000 in legal fees and court costs. And this was completely avoidable. All right, so here's what you need to do after you sign your trust document. you have to immediately work with an attorney that can help you transfer your assets into the trust. Again, if it's a real estate, we usually use a deed. A grant deed would be probably preferable. If it's a bank account, you could name the trust as the beneficiary of that bank account, or actually retitle the bank account to the name of the trust. If it's an S corporation, LLC, or partnership, we want you to assign your interest in that entity to the trust. So it's essential to make sure that when you create your trust, you actually transfer and attach your assets into it. Mistake number 3, failing to review your trust every few years. One of the other mistakes I get to see is that people treat their trust as if it's just a one-time project. They sign it and they completely forget about it. And it may take them 10 years, 15 years, or even 20 years to go back to it and maybe take a look at it again. That's a massive problem because both your life and law changes. Here is a real example. Before 2011, estate tax planning often required AB trust structure. When the first spouse died, the trust would split into 2 subtrusts, Trust A for the surviving spouse and Trust B for the deceased spouse, and it was intended to preserve the deceased spouse's estate tax exemption. Back then, this made sense, but in 2011, federal law changed. Now, a surviving spouse can elect to port the unused exemption from the deceased spouse by filing a particular tax return called a 706 tax return. That means in many cases, you may no longer need a bypass trust just to preserve the exemption. And keeping that outdated AB structure in place today can cost your family dearly because assets in the B trust do not receive a full step up in basis when the second spouse passes away. So if your spouse dies, the home or the investment in the B trust may have capital gains built in that trigger unnecessary taxes when your kids inherit them. I've seen families pay hundreds of thousands in avoidable taxes, all because their trust was written before 2011 and they never updated the trust. That's why I recommend reviewing your trust every 3 years, even if nothing major has changed in your life. If tax law shifts, if your family grows, or if your net worth increases significantly, you want to make sure your plan still works. The cost of reviewing your trust every few years is minimal. The cost of failing to do it could be millions in taxes, probate, or family conflict. All right, mistake number 4 that you want to avoid, and that is choosing the wrong trustee or not having a succession plan. This mistake can destroy families and cost millions. I see people name their eldest child as successor trustee without thinking about whether that person is actually qualified, or worse, they don't name alternates when their first choice can't or won't serve as the trustee. Being a trustee is not just an honor. It's a serious legal responsibilities. Trustees have fiduciary duties under California law that can result in personal liability if they're breached. We're talking about duties of loyalty, duties of care, and prudent investments. These aren't suggestions. They're legal requirements with legal consequences. I've seen family relationships destroyed because someone was named a trustee who was not equipped for the job. They made poor investment decisions, failed to keep proper records, or played favorites among beneficiaries. The result was litigation that cost the trust hundreds of thousands of dollars and turned siblings against one another. All right, so here's what you need to consider when you're going to choose a trustee. Does your chosen trustee understand investments? Can he or she keep detailed records? Are they organized and responsible? Do they have the temperament, the right temperament, to deal with beneficiaries fairly? If the answer to any of these questions is no, you need to reconsider your choice for a successor trustee. Also, always name at least 2 alternates. I've seen trust become unmanageable because the named trustee became incapacitated and there was no clear succession plan. Consider professional trustees for large trusts or complex family situations and family businesses. Mistake number 5, failing to protect your children's inheritance from divorce, creditors, and themselves. Many parents believe that establishing a trust for their children ensures that the assets are safeguarded. However, if the trust mandates outright distributions at specific ages, such as 25 or 30, the assets become the personal property of the beneficiary. It means divorce risks, creditor claims, and financial mismanagement. All right, so a more protective approach is to establish a discretionary lifetime trust. I refer to it sometimes as inheritance trust for each beneficiary. This structure allows the trustee to manage distributions based on the beneficiary's needs while keeping the assets protected from external threats. In California, if you create a trust like this and it's structured correctly, it has these spendthrift provisions in there, it can now really provide a great deal of protection for the beneficiary against his creditors or her creditors and in a divorce scenarios. Moreover, by granting the beneficiary a limited power of appointment, they can direct the remaining trust assets upon their passing, providing flexibility without exposing the assets to their creditors. In essence, while outright distribution might seem straightforward, they can inadvertently expose your children's inheritance to significant risks. Opting for a well-structured discretionary trust or an inheritance trust ensures that your legacy is preserved and protected for future generations. This is what you need to do right now. These 5 mistakes are costing people millions of dollars every year in California. The good news is that they are all preventable if you know what to do, what to look for, and hire the right attorney. All right, so first, you got to understand what your current trust actually does and doesn't do. If you think your revocable living trust is protecting your assets from lawsuits, you need to have that conversation with an asset protection attorney immediately. Second, make sure your trust is properly funded. Third, evaluate whether your chosen trustees are actually qualified for the job and make sure you have proper succession planning in place. Fourth, I need to make sure you understand the tax implications of your trust structure and make sure you are in compliance with all reporting requirements. Now, if you're thinking about real estate investing or you already own investment properties, there's something else you absolutely need to know. The way you hold title to your real estate can make or break your asset protection strategies. Questions I get is, should I use an LLC? Should I use a land trust? Is a corporation better for certain situations? So I've put together a comprehensive analysis of the best entity structures for real estate investors in California. This is not a generic advice you will find anywhere else. This is specific to California law, California taxes, and the unique challenges we face here in California. If you're serious about protecting your real estate investments, you don't want to miss this next video. The wrong entity choice can expose you to unlimited personal liability or cost you thousands in unnecessary taxes every year. I will see you over there.